Welcome to this channel Global Reach. Subscribe this channel and press the bell icon for more informative videos. Today we will learn something about NAB, which is National Accountability Bureau. National Accountability Bureau follows the National Accountability Ordinance 1999. This is the official document of NAB, which gives the assistance in various legal matters. And today in this video we will specifically learn about the section 9 of the National Accountability Ordinance 1999. Section 9 exclusively talks about what is corruption and what are the corrupt practices which are mentioned in this document. So there are total 3 subsections in section 9, which are A, B and C, and in subsection A there are total 12 clauses. So let's begin. In section 9 subsection A holder of the public office or any other person is said to commit or to have committed the offense of corruption and corrupt practices. This is the title of subsection A, and there are total 12 clauses which describes about the different categories of corruption and the corrupt practices. What are different possibilities of doing corrupt practices? So let's begin with the clause 1. Clause 1 says, if he accepts or obtains from any person or offers any gratification, directly or indirectly, other than legal remuneration, as a motive or reward, such as is specified in section 161 of the Pakistan Penal Code, for doing or forbearing to do any official act, or for showing or forbearing to show in the exercise of his official function, favor or disfavor to any person, or for rendering or attempting to render any service or disservice to any person, then such person is said to be doing any kind of a corrupt practice. So section 9 subsection A clause 2 says, if he accepts or obtains or offers any valuable thing without consideration, or for a consideration which is knows to be inadequate, from any person whom he knows to have been or likely to be concerned in any proceeding or business transacted or about to be transacted by him, or having any connection with his official function, or from any person whom he knows to be interested in or related to the person so concerned, then such person is also said to be doing a kind of corrupt practice. So clause 3 of section 9 subsection A says, if he dishonestly or fraudulently misappropriates or otherwise converts for his own use or for the use of any other person any property entrusted to him or under his control, or willfully allows any other person so to do, then he is also said to be doing a kind of corrupt practice. It means he is not allowed to use any property which is entrusted to him by the government officials or by the NAB, which are proceedings under any kind of case, so he cannot use that property. Clause 4 of section 9 subsection A says, if he by corrupt, dishonest or illegal means obtains or seeks to obtain for himself or for his spouse or dependents or any other person any property, valuable thing or pecuniary advantage, so he is also said to be labeled as doing a corrupt practice. It means he cannot use any kind of property, any valuable thing by any kind of corrupt, dishonest or illegal means. So clause 5 of section 9 subsection A describes, if he or any of his dependents or benamidar owns, possess or has acquired right or title in any asset or holds irrevocable power of attorney in respect of any asset or pecuniary resources disproportionate to his known sources of income, which he cannot reasonably account for, or maintains a standard of living beyond that which is commensurate with his sources of income, then such person is also said to be doing a kind of corruption or in a corrupt practice. In simple words, if any person have assets which are beyond his known sources of income, or if he holds any kind of authority or power which is beyond his non-official powers, then he is said to be doing a kind of corruption and corrupt practice. So clause 6 of section 9 subsection A says, if he misuses his authority so as to gain any benefit or favor for himself or for any other person, or renders or attempts to render, or willfully fails to exercise his authority to prevent the grant or rendition of any undue benefit or favor which he could have prevented by exercising his authority, then such person is also said to be doing a corrupt practice. This clause is also relevant to the government official because authority is given to any officer which is doing a job in federal or provincial government. So if he there are two different scenarios in this. If he misuses his authority for doing any kind of corrupt practice, or the second is if he willfully fails to stop any kind of corrupt practice or any kind of corruption, then in that case he will also said to be a part of doing a corrupt practice. Clause 7 of section 9 subsection A says, if he has issued any directive, policy or any SRO, statutory regulatory order or any other order which grants or attempts to grant any undue concession or benefit in any taxation matter or law or otherwise so as to benefit himself or any relative or associate or a benamidar or any other person, then that person will also be a part of doing a corrupt practice. Clause 8 of section 9 subsection A says, if he commits an offence of willful default, then he is also doing a corruption. Clause 9 of section 9 subsection A says, if he commits the offence of cheating as defined in section 415 of the Pakistan Penal Code 1860 and thereby dishonestly induced members of the public at large to deliver any property including money or valuable security to any person, then such person is also doing a corruption or corrupt practice. So this basically talks about the offense of cheating. Clause 10 of section 9 subsection A says, if he commits the offense of criminal breach of trust as defined in section 405 of the Pakistan Penal Code 1860 with regard to any property including money or valuable security entrusted to him by members of the public at large, then such person is also said to doing a corrupt practices. So this clause talks about the criminal breach of trust. Clause 11, section 9, subsection A says, if he, in his capacity as a banker, merchant, factor, broker, attorney, or agent, commits criminal breach of trust as provided in section 409 of the Pakistan Penal Code 1860 in respect of property entrusted to him or over which he has dominion, then he is said to be doing a corrupt practice. Clause 12 is important because it refers to all the previous clauses from 1 to 11, and let's talk about this. This clause says, if he aids, assists, abates or attempts or acts in conspiracy with a person or a holder of public office accused of an offence as provided in clause 1 to 11, then that person is also said to be doing a corruption or a part of corrupt practice. In simple words, if there is any person who is accused of an offense, and if any person is helping him in his case and assisting him against that case, then he is also a part of that conspiracy which falls under the category of doing a corrupt practice according to this ordinance. So section 9 subsection B says, all offences under this ordinance shall be non-bailable and notwithstanding anything contained in section 426, 491, 497, 498 and 561A or any other provision of the code or any other law for the time being in force. No court shall have the jurisdiction to grant bail to any person accused of any offence under this ordinance. In simple words, no other court independently can grant bail to any person who is accused of committing any kind of offence according to this ordinance. Only Chairman NAB with an approval of the court which is investigating or inquiry against any case. Then after the investigation and inquiry, the bail can be granted to a person. So section 9 subsection C says, if after completing the investigation of an offence against a holder of public office or any other person, the Chairman NAB is satisfied that no prima facie case is made out against him and the case may be closed, the Chairman NAB shall refer the matter to a court for approval and for the release of the accused if in custody. In simple words, the Chairman NAB with an approval of the court can release an accused person when he will be satisfied that no any other prima facie case is made out against him. The prima facie case is that case which is made at first impression, which is not yet proved by evidence. So only after the completion of investigation, the accused will be allowed to release with an approval of the Chairman NAB with the approval of court also. If you have learned anything from this video, then please subscribe this channel and press the bell icon for more informative videos and leave your feedback in comment section. Thank you so much for watching.